Welcome back. With us now is Austin Byrd of Bailey & Greer. We're talking about mass torts, specifically defective drugs and medical devices. Austin, we've talked a lot on the medical side of what the issues are as far as and how you get it regulated and all of this, but we haven't talked a whole lot about the legal side of this. And my understanding, the big thing with mass torts, a lot of people think, oh, well, that's a class action, but really it's a multi-district litigation.
That's right, Vince. Multi-district litigation is not like a class action. In a class action, everyone typically suffers the same injury and damages. In multi-district litigation, the fact pattern that gives rise to the injury is very similar, but the damages are individualized, and so you have to look at each person's case, and each remedy is going to be specific to that person's injuries. Multi-district litigation is a special procedure in federal courts, and it speeds up the process of handling hundreds and hundreds or even thousands and thousands of claims based on the same facts or very similar facts. So what happens is there'll be lots of lawsuits that pop up around the country, all claiming, for instance, that Actos caused bladder cancer in a particular patient. Well, it would be impossible for the company to go defend all those lawsuits and send its sort of scientists or experts into 50 or 100 different courts. So all of those actions are transferred to one court, and for the pre-trial work, like the identification of experts and the taking of discovery depositions, those are all handled by one federal judge who's appointed by a judicial panel on multi-district litigation. Much more efficient for the federal court system, much more efficient for each individual injured person, because the costs of all of that pretrial discovery can be shared by the hundreds or thousands of people who have been injured. And that makes it possible for a person to get into court and to achieve a better remedy at a lower cost.
Yeah, so how long does a multi-district litigation take?
They take a long time. You know, in law you learn that the wheels move slowly, and it takes quite a long time to go through this process, in particular because you're dealing with fairness to hundreds or thousands of people at the same time. While it's more efficient than handling all those cases individually, a person could still expect this whole process to take 3 or 4 years from the time they maybe call a lawyer until it's all over and they receive whatever remedy they're entitled to.
Okay, so say we've got somebody at home that's sitting there saying, well, I took Actos or I took Pradaxum, and what steps should they take if they want to pursue something or see if they've got a case?
Well, I think first you talk to your doctor and ask if your doctor knows if there's any particular concern or controversy about a drug or device. And likelihood is the doctor will be aware through the literature they read. You can also call a lawyer, and I think you should speak to a lawyer who is very familiar with this mass tort medical device and pharmaceutical litigation. Because all of these cases get transferred to one court, calling your local lawyer is not always the best solution. The lawyer that handled your real estate closing is not going to prosecute the case in, for instance, with DePuy ASR metal hips. All of those cases are consolidated into Toledo, Ohio. So if you live in Memphis, you know, you can call a lawyer that really focuses on this, or if you live in Iowa, you can call a lawyer that really focuses on this in Memphis, and that case will be handled in Toledo. But I would talk to your doctor, then talk to a lawyer to find out whether you have a remedy.
Okay, and then I guess with the medical devices on that, is that on most of those, are you going to have pain in the region in which the medical device was put in, or?
You know, it all depends on whether you're developing a systemic injury or whether it's a localized injury, and that's all going to be based on the product that you got. But I think if it's a medical device, a lot of times it'll be localized. If it's a pharmaceutical product, it's going to result in a particular disease state diagnosis.
Okay, because I know on occasion some of the probate stuff I've done where we've got a VA claim or something, and somebody's saying, well, my dad was over here and he got exposed to X in this war or whatever, and we think that caused this, or, you know, and it's one of those that there's some remoteness to this, and then the question always becomes is, you know, when somebody asks me that, I'm like, well, why do you think that? And I think that's the hard thing on the medical device stuff is you know, could my hip implant be causing pain in another area of my body, or you know?
Well, let's talk about that because You know, the whole process, just because you took a drug or just because you received a medical device doesn't mean, and you see that advertisement
And
on
just
TV.
so you know, I'm getting the wrap-up signal.
Okay.
So.
Each person's case is going to be looked at individually, and you have to prove that you sustained an injury from that product in that case. Just because you took the drug or got the device doesn't mean you were injured. So you have to have a lawyer who's really going to understand what the indications of the injury are for you.
Okay, that makes perfect sense. Our time is up for this edition of Legalese. I would like to thank our guest for taking time out of his busy schedule for being with us and sharing his thoughts and insights. If you would like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. Thank you for joining us today, and be sure to join us next month for more discussion of legal topics. Until then, I'm Vince Perryman. Thank you for watching.